You're watching Beyond Market, where we bring you up to speed on development outcomes in Africa. I'm Kenneth Igbomor, and thank you so much for joining me on the show. On today's show, we'll ask the question, how can the Nigerian Bar Association help to strengthen judicial integrity and capacity? And my guest will join us today to discuss this. You can join the conversation on social media. Let us know what you think. The hashtag to use is Beyond Market. You can also hit me up at Kenneth Igbomor. Now, the United Nations says the integrity, independence, and impartiality of the judiciary are preconditions for fair and effective access to justice. And I have with me Babajide Ajibade, is the managing partner at S.P.A Ajibade CO, and he joins me now as we explore how the Nigerian Bar Association can help to strengthen judicial integrity and capacity. Thank you so much for your time today on the show. And let's start with that point and understand how the Nigerian Bar Association can play a crucial role in helping to strengthen judicial integrity and capacity.
Thank you, Kenneth. I think the Nigerian Bar Association not only can, but should and must play a critical role in ensuring judicial integrity, capacity, and all the other adjectives you've used to describe where we would like our judiciary to be. The reason why the Nigerian Bar Association plays a critical role is because judges, after all, are not born. Judges are lawyers who decided to go to the bench. And as lawyers, before they become judges, they were members of the Nigerian Bar Association. So the Nigerian Bar Association definitely has a critical role to play. And I think the role has to be at that point, at the point at which our colleagues decide that they want to go onto the bench. The Nigerian Bar Association has a role to play in ensuring that it is those of our colleagues who have the right credentials in so many different respects that make that journey from the bar to the bench. Credentials in terms of their capacity, credentials in terms of their integrity, and credentials in terms of their independence of mind, independence of thought. Because as I said to another interviewer recently, independence is not just a vague concept. Independence really has to do with the mindset of the individual.
All right, but let's look at how the NBA's role has evolved over the years, especially as being that prime defender of the bar and the bench. You know, I'd like you to speak to how we've seen that evolve over time and where we would like it to be.
Well, I think that is the real problem. Historically, the Nigerian bench had a sterling reputation. It had a sterling reputation, and we exported judicial officers to other African countries, even to international courts. I mean, you talk about the late Taslim Elias, who was at the the International Court of Justice. In those days, it was the best of the bench, the best of the Nigerian legal profession that went to the bench, and it was manifest in the quality of the judgments that our judges delivered. It was manifest, like I've said, in the fact that our judges were in high demand in other parts of the continent and the world. Our judges went on to be chief justices of the Gambia, of Sierra Leone, of Botswana, various parts of Africa. But what has happened over the years, unfortunately, is that the situation seems to have reversed. It is not necessarily the case. Of course, I'm generalizing here. We still have some brilliant judicial officers, but it is not generally the case that it is the best of the profession that is now going to the bench. And that is what has caused the challenges that we're confronted with now in terms of a lack of independence and I dare say a lack of quality even in the judgments that are coming out of some of our courts.
All right, so let's plug the missing links here and let's understand how we can enhance Nigeria's judiciary as an institution. Well,
so the causes of the problem are multifarious. One of them, in my view, is clearly the selection process. It is not possible to, I mean, we can go, go and think about the good old days when the best of the bar were given a tap on the shoulder and invited, to come onto the bench because they had been identified by those who were on the bench at the time as being of the appropriate quality. I don't think we can go back to that. The size of the judiciary, the size of the requirements for judicial capacity make that an unreasonable approach, no matter how much we might reminisce about those good old days. So now judges, lawyers apply to go to the bench. They choose to make that transition. And I think what we must do is to make that process, that filtration process, a lot stiffer, make the quality control a lot better. The flip side to that, in terms of encouraging the best to apply, is that we need to address concerns about the quality of the conditions under which our judicial officers serve. Because the truth is, it's going to be extremely difficult to get the best of the bar to go to the bench if the conditions of service are either perceived or actually are not sufficiently robust to attract the right kind of talent. So I think the challenge really is greater resources and a better selection process.
All right, but very recently we've seen the judiciary come under the spotlight, not for the very best of reasons. And over time we've seen that has helped to build some perception about the judiciary in the minds of the public. But I'd like to know how we can see that public perception of the judiciary being more or less rebranded into something that is more stellar as it should be.
It has to be a root and branch job. There's no shortcut to it. First, perception is 9/10 reality. So no matter how one might want to wish it away, there is a perception that there is corruption in the Nigerian judiciary. The only way I can see that one can deal with that is first, at least in relation to those who are already on the bench, is to have a much more robust disciplinary process that will give confidence to the public and to the users of judicial services that where corruption is identified or reasonably suspected, that there is a will to actually deal with it decisively. Because if corruption is, be it on the bench or elsewhere, it's criminal conduct. Now, if there's a perception that those who engage in it are merely given a slap on the wrist, then the perception that that problem is not going to go away anytime soon remains. But if there are examples made of those judicial officers, and by the way, and I must say quickly, and their accomplices, because it takes two to tango. Typically, where you have a corrupt judge, you have a corrupt lawyer as well, who has acted as a middleman. So this is not just about judges. This is about the legal profession as a whole. I think we need to make a few significant examples of those who engage in this nefarious conduct. And that will give some confidence to, or more confidence to the public that this problem is being dealt with. Then, like I said earlier, we now need to also deal with the input point, because there's no point dealing with eradicating corruption amongst serving judicial officers if we are appointing more corrupt or potentially corrupt judicial officers. So I think we need to improve the quality of the appointments process to eliminate, to the greatest extent possible, the possibility that those who have been appointed have a predilection for corrupt conduct. And then to improve on the disciplinary processes and the detection processes to ensure that those who are already in service don't engage in this conduct, and that there's a deterrent. Because the only deterrent to bad behavior really is detection and sanction.
Right, but what active role can the Nigerian Bar Association play in all of this?
Well, I mean, in the detection side of it, obviously, Nigerian Bar Association has to play a critical role. And in the filtration process, the Nigerian Bar Association is expected to play a role even now. The problem, in my view, is that for a variety of reasons, the Nigerian Bar Association has not been able to play that role effectively. It is not supposed to be possible for any lawyer who's aspiring to become a judge to achieve that objective or to secure that appointment without the Nigerian Bar Association having a significant say-so in whether that person is fit and proper or not. So quite clearly, if there's a perception that judicial officers are attaining or achieving their objectives to assume that office and they turn out to be corrupt, that means that the Nigerian Bar Association is not playing its proper watchdog role in ensuring that it's the right quality of people that go onto the bench. Now, like I said, the problems with that are structural. There's a process that those aspiring to go to the bench ought to go through. That process presupposes that there's a high degree of transparency, that openings in the judiciary are advertised, and that the names and identities of those who are seeking to be appointed is made public, and that the bar then has an opportunity to comment. Because at the end of the day, the best judge of a lawyer's character traits, capacity, capability, is really an assessment made by his or her colleagues. But unfortunately, the way the system is working in Nigeria at the moment, except, of course, the exceptions to the rule, but generally, it is shrouded in secrecy, and you tend to just hear of appointments after the event. So I think that the starting point is the Nigerian Bar Association must insist on the letter of the regulations that prescribe the process for judicial appointments being followed. Must insist on those regulations, if I had my way, being strengthened further to increase the chances that we would be able to filter out those who are not fit for the role and make sure that they don't actually get onto the bench.
All right, Mr. Ajibade, I needed to hold that thought for a second. We'll take a quick break, and when we return, definitely we'll get into more aspects of this conversation. I've been speaking to Babajide Ajibade, he's the managing partner at S.P.A Ajibade CO. Beyond Markets continues after the break. Welcome back to Beyond Markets. If you're just joining us, my guest today on the show is Babajide Ajibade. He is the managing partner at S.P.A Ajibade CO. Thank you so much for your time on the show, sir. And now let's get to one part that really excites me. And for me, it's the part about talking about the rule of law and protecting human rights. And I would like to know, what the NBA has been doing on this front and how we can move the needle for, better outcomes on human rights and the rule of law.
Well, the human rights and the rule of law really are all functions of, in my view, the efficiency of your justice sector. The arena or the venue for protecting and securing the protection of human rights and of enforcing the rule of law is the courts. And in line with the discussion we were having before the break, your ability to do that really hinges on the efficiency of your justice sector and on the quality of the personnel. So for me, the greatest challenge with enforcing the rule of law and of protecting the human rights of Nigerian citizens today is the inefficiency in our justice sector. Cases take too long to go through our courts. And this applies right across board, criminal matters, civil matters, the works. Our system, our justice sector is just not working properly at the moment. So I think that what the Nigerian Bar Association can and must do to improve on the enforcement of the rights of citizens and upholding of the rule of law is to improve, do its bit to ensure that our justice sector is better, is a better functioning machine. And this again, as I said when we were talking about judicial appointments, for me, it is really down primarily to resources. On a bad day in a court in Lagos, where I practice primarily, you could have 40 cases on a court docket. And many a times, it's just not realistic to expect any judge to go through 40 cases in one day. So many a times you find that cases are listed, the judge is only able to get through maybe between 5 and 10. And then the rest, just have to, they're asked to take a date. You don't sit. So our courts are just not working efficiently. The judges are overworked. There are not enough of them. And those of them that are there are not all working, in my view, to optimal standards. So the enforcement of the rule of law, the protection of human rights is tied to having a properly functioning justice sector, and we don't have that at the moment.
All right, so talking about still on the topic of administration of justice, and we understand how important that is, and the need to ensure equity and fairness in court rulings and judgments. I'd like to see how we can ensure that the justice system performs its functions despite the political setting.
Okay, I think I get your meaning now. Well, in several instances where there are failings of the rule of law, or where the human rights of citizens are being abused, this would typically, or in several instances at least, will involve agencies of the state. And you're right. I mean, our political actors oftentimes are the aggressors when these things happen. The inability of the justice sector to deal decisively with this is a matter of great concern, because you have too many instances in which judges, despite all of what I've said about the inefficiency of the justice sector, judges have given judgments or made orders that are designed to protect the rights of citizens or to enforce their rights, and these orders have been ignored by the executive. And this is a major concern. The judiciary, in my view, is not doing enough in terms of putting its foot down, because after all, the judiciary is a third arm of government. It is not supposed to be at the mercy of any other arm of government. And when it makes orders and those orders are disobeyed, then it must be seen, to be putting its foot down and to be insisting that those orders be obeyed. And we have examples, there are a few flashes we get from time to time of judicial officers who appreciate this and who act in the manner that one expects. But that tends to be the exception rather than the rule these days. So unfortunately, at the risk of sounding circuitous, it goes back to the same point. I think the inability of our justice sector at present to sufficiently uphold the rule of law and the enforcement of the rights of citizens, where the executive has gone rogue, it falls upon the quality of our judicial personnel. So the NBA as an organization and lawyers, of course, have their own role to play. They have their own role to play in prosecuting these cases efficiently, presenting the cases properly. But ultimately, in my view, if a court makes an order in protection of the rights of citizens and that order is not obeyed, and if lawyers make the necessary applications, the enforcement really is down to the courts. And like I said, we have instances. I'll give you one instance that always comes to mind when I discuss this. Is an instance of a judge in Nigeria who met with a refusal to obey his orders by an agency of government refused to entertain any further applications or actions brought by that particular agency, and said that he would not listen to any matter involving that agency until his extant orders had been obeyed. Now, that for me is the kind of attitude that our judiciary needs to adopt right across board to get the executive to start doing the right thing.
All right, let's get back to the issue of capacity. And I'd like to hear your suggestions on how best to mitigate the impact of COVID-19 on the judicial processes.
The impact of COVID-19, it's something that we're all struggling with in a way, and it's this might not everybody will agree with this, but I think that COVID-19 has some positive impact in terms of changing our thinking in the justice sector in Nigeria, because some of the things that we are now considering, that we're now trying to implement, are things that we could and should have done a long time ago. Increased use of technology is now being considered. These are things that we've been talking about for quite a long while, and which we should have been doing a lot better with. Of course, it's going to take some doing, requires significant investment, both in terms of hardware, software, and capacity building, training for judicial officers, support staff, and for lawyers, but it has to be done. The other thing, simple things, there are quite a lot of low-hanging fruits, things like scheduling, because of the restrictions on the number of persons that are supposed to be in any given confined space because of the COVID-19 regulations. We're now talking about scheduling in our courts. I mean, this is something that some of us have been agitating for many years now, to say that there's really no point having a court filled to the brim with litigants and lawyers whose cases may never get heard. I already told you that on a bad day in some of our courts, you have up to 40 cases listed. So you can imagine the state of those courts when all the litigants involved in those 40 cases and the lawyers are all packed into the courtroom, whereas only 4, 5, 6, 7 of those cases are going to be heard. Now we're having a lot more consideration being given to scheduling, because we don't want too many people in a confined space. So people are being, litigants are being allocated specific times of the day for their matters to be called, and they're called into the courtroom one at a time. These are some of the innovations that COVID-19 has brought about, and I think that they're innovations that we should have, they're things that we should have been implementing even before now. And I'm hopeful that even if, not if, when, by God's grace, the pandemic goes away, that we will sustain these innovations, because they do make for a much more conducive system of justice delivery.
All right, now talking about delivery and justice delivery, and I'd like to understand what the sections of the NBA can bring to the table.
Oh, the sections of the NBA are a wonderful tool. As you know, the NBA, or as you may know, the NBA is a very, very broad church. The legal profession is one of the most diverse and versatile professions that you can have. Not all lawyers practice the same type of law, and not all lawyers have the same interests. So the establishment of the sections of the NBA is a wonderful vehicle for ensuring that lawyers who have similar interests can be accommodated, and that they have a portion of the NBA where their own specific interests and concerns are being articulated. So we've got 3 sections. We've got the section on business law for those who are commercially minded. We've got the section on legal practice. We've got SPIDA, the section for professional interest and development law. And this model is not an NBA invention. We borrowed this really from what happens in the International Bar Association, where quite a few of us attend. And the IBA is set up on a similar, not exactly identical, but similar structure. So I think the sections of the NBA are a wonderful tool for ensuring that lawyers with different interests can group together and engage in activities that are of particular interest to them. But I think it is important, though, that it is realized that the sections are just that. They're not parallel organizations. They're sections of the NBA. And I think the NBA is a lot stronger for having those sections because it allows us to accommodate the entire profession. And there's still other groupings within the profession that are not necessarily captured by the existing sections. That's why, in addition to the sections, we also have various fora and various specialist groupings of lawyers.
All right, then. Thank you so much for your contributions on Beyond Markets today. I've been speaking to Babajide Ajibade. He's the managing partner at S.P.A Ajibade CO. And that's a wrap on Beyond Markets for today. And thank you so much for being a part of the show. Remember, you can watch the show at 5 p.m. West African time daily and have access to all episodes of Beyond Markets on our website. That's at cnbcafrica.com. From me and the team, enjoy the rest of your day.